Since my evidence was the very thing I was being prosecuted over, during my recent local court hearing, my legal representative requested that notes from the former ICAC Commissioner, Mr. David Ip, regarding my evidence be presented in court to gain a better understanding of the motives behind why the Commissioner and counsel assisting lied to me and acted unprofessionally. This was denied. Now, former Commissioner, Mr. David Ipps, was also requested to come into court to answer for his behaviour. This too was denied. At first, Mr. Robert McAway, solicitor for the RCAC, was unwilling to confirm the existence of any notes made by former Commissioner Mr. David Ip.
In this particular matter, firstly, the issuing party does not know whether or not there are notes. Perhaps I'll do the notes first. Does not know whether or not in fact notes exist, what those notes might be about, and my respectful submission is incapable of positing a basis upon which it could be suggested that those notes, if they existed, would assist his client.
Then, when presented with an excerpt from the RCAC public inquiry where the former Commissioner, Mr. David Ip, lies, Mr. McAway admitted to the existence of notes made by the former Commissioner and of having read them himself.
I can place on the record that I have examined the notes.
The court suggested that there was no forensic purpose for the Commissioner's notes or for him to come in as a witness and answer questions, even though the very reason I was being prosecuted surrounded the evidence I gave at the RCAC inquiries, and the Commissioner's behaviour directly affected this evidence. Former Commissioner Mr. David Ip should have been called into court, and his notes should have been made available for a fair and just trial. Magistrate Mr. Michael Barnes heard my case at the local court on the 10th of September 2013. Before coming to New South Wales, Mr. Barnes was a Queensland State Coroner. In 2005, he made headlines when he presided over an inquest into one of Australia's most controversial death in custody cases. The initial inquest into the death of Mulrunji Doonergy on Palm Island was, and I quote, sensationally aborted when Mr. Barnes stood down amid claims of bias, end quote. The full article from which this quote was obtained can be found at the following website. An additional article dated the 3rd of March 2005 with further information can be found at the subsequent website. At the conclusion of my local court hearing, Magistrate Mr. Michael Barnes misquoted me and provided inaccurate information in his submission. My case ran for approximately a week, and on the 14th of July 2014, Mr. Barnes convicted me under Section 87 of the ICAC Act. Mr. Barnes is now New South Wales State Coroner. He was promoted to the position of New South Wales State Coroner on the 11th of December 2013, approximately 2 months after my local court proceedings began.